Currently, 60 million American workers are silenced by forced arbitration, 1/3 by NDAs. The goal is to educate as many as possible: women, people of color, and lower wage workers.
I just graduated from college, I'm about to enter the workforce, and I have no idea what silencing mechanisms are. How do I get help?
Cuando comencé mi primer trabajo en Estados Unidos, firmé un sinfín de papeles y estaban en un lenguaje que no podía entender por completo. ¿Acaso renuncié a mis derechos?
That's why we built the Love Where You Work AI tool. It's a first-of-its-kind tool that identifies silencing mechanisms like forced arbitration and non-disclosure agreements in just seconds. It's as simple as uploading your paperwork, waiting for the tool to analyze it, and then delivering a detailed report to you. It's anonymous, free, and in multiple languages.
The AI tool also suggests action items to advocate for change and working to eradicate existing biases by ending toxic workplace cultures.
We measure success by the silence we break.
Because every worker deserves a voice.
And welcome everyone to the launch day. Julie, we finally made it. We are Gretchen Carlson and Julie Roginski, the co-founders of Lift Our Voices. We made it to this day. We've been working on this for a really, really long time. There's so many people you're going to meet along the way today who've helped us get to this point. But we're really excited about launching the Love Where You Work AI tool today. And thank you for being a part of this webinar. So as you may know, at Lift Our Voices, we have spent years fighting the systems that silence workers, specifically NDAs and forced arbitration clauses that too often prevent people from speaking out about harassment, discrimination, and retaliation. And the reality is that most workers have no idea what they are agreeing to when they sign an employment contract. And by the time people finally understand the fine print, it's probably too late. So just real quickly, 84% of all American workers are currently under forced arbitration. 84%. It's exploded over the last 40 years, and they don't understand what it is. 1/3 of all American workers sign NDAs on their first day of work, thinking they're just protecting trade secrets at their company. But those NDAs are so much more expansive. So at Lift Our Voices, we have passed 2 federal laws to fight that for sexual misconduct, but we still have a long way to go for all the other protected classes. And education on these issues is key. And that's why we're so excited to start a movement today with this new AI tool. Julie?
Thanks, Gretchen. And thank you to all of you for joining. We are, just as Gretchen mentioned, so deeply thrilled to unveil this AI tool and explain to you what it does and how it's a total game changer for women, people of color, members of the LGBTQ community, every worker in the workplace. We built this AI tool because we wanted to create something practical, accessible, and immediate, something that helps workers better understand what they're signing before harm even occurs and provide them with solutions. It's free. Currently, it's in both English and Spanish. We hope to raise enough money to expand it to many other languages. It's anonymous and it's accurate, and that is actually very crucial. We compared responses from our AI tool to responses in ChatGPT and Gemini. Both of them yielded wildly inaccurate outputs that would potentially get a worker in deep trouble if they were to follow the advice that was given to them by other AI tools. Ours is specifically trained to hone in on silencing mechanisms. We really believe here at Lift Our Voices that transparency should not begin after a crisis. It should begin the moment someone is handed a contract. And that's why we want everybody to have access to this free, first of its kind AI tool so that they can know what is in their onboarding paperwork from the moment they receive it, not when it's too late. In order to explain all this to you and to set the stage for why this is a problem plaguing the American workforce at the moment, I want to bring in our good friend, just a brilliant woman, Miriam Gillis, to help us understand why this moment matters and why legal reform alone, we've been working on it, we've had a lot of success at both the federal and state level, but why legal reform alone is not enough. We're honored to welcome Miriam. She spent years examining forced arbitration, workplace power structures, and access to justice. Miriam Gillis is the Catherine Waugh McCullough Professor at Northwestern Law School and one of the country's leading voices on arbitration and workers' rights. We are so grateful she's joining us today, and Miriam will let you take it away from here.
Great, thank you. And thank you both for having me. And thank you for doing all of this work. I think this is extraordinary. I'm so excited to be part of it. As Julie says, I've been working on legal reform, but when the laws can't get changed as quickly as we need, I think we have to take it to the people, and that's what you all have done. So I want to just thank you for that. So my job is to set the stage a little bit. So this is like a mini law school class. I want to talk a bit about the problems that we see in employment contracts, because this all starts with the employment contract. Most people think of law as something that happens after a problem arises. You hire a lawyer, you go to court to resolve a dispute. But for workers, the real allocation of power happens much earlier, at the moment of signing your employment contract. And keep in mind, it doesn't have to actually be a signature. In lots of employment contexts, it can be clicking on a terms and conditions box. It can be simply accepting paperwork. So your signature is not even necessarily required to show consent. Employment contracts, especially standardized ones, and most of us are subject to standardized employment contracts, don't just set the terms of your job. They quietly reallocate legal rights, and they do so in a context where there's no bargaining. So what looks like a standard onboarding step, right, the first day of work that you just sort of kind of get through all that HR material, is actually where access to justice is often foreclosed. So if we go to the next slide, I want to take nothing away from all of the hard work that Gretchen and Julie did to get important legislation through what has been a very deadlocked Congress. Their work got us a statute, the Ending Forced Arbitration and Sexual Harassment and Sexual Assault Act, as well as the Speak Out Act. These are important interventions in the legal system, but they are targeted interventions in a much larger ecosystem. Moreover, employers and contract designers adapt quickly, and they can preserve the same underlying dynamics with slightly different forms, and most of us will never understand what's really happening. So the deeper issue is structural, right? We could try to play whack-a-mole and just keep trying to get statutes through Congress, but if we're going to rely on private contracts to govern our rights in the workplace, then reform at the margins doesn't really sort of shift the balance towards workers. What we need is to take more control ourselves. Even highly educated workers, and I think some of you watching this might be thinking, well, I know what I'm doing. I can read a contract. Well, I'm a law professor, and I'll be honest that I can't really understand my employment contract. I think even highly educated workers don't understand what they're signing. And it's not because we're lazy or careless, but because the system isn't really designed for our comprehension, right? Employment agreements are dense, they're technical, and they're usually presented in a moment where you're focused on the job, right? Not on parsing legal rights. And the most important terms, like forced arbitration, really don't feel salient at the moment that you're signing the contract, right? It's when something goes wrong that these provisions really come into play. So what we call consent often operates as a legal fiction in the modern era. And that means if we want to change outcomes, if we want to empower ourselves, we have to start with the contract itself. So that's sort of a basic primer, but I'll send it back to Julie and Gretchen to pick up from there.
Miriam, thank you so much. And Miriam's going to stick around for the entire webinar to take any of your questions because she is the expert on these issues. And thank you so much for that presentation, Miriam. So we've now talked about the problem and how pervasive it is, but now we want to actually show you the solution in action, which is the Love Where You Work AI tool. So we partnered with Dr. James Gaskin to build this Love Where You Work AI tool with one goal in mind, and that was to help the everyday worker understand the complicated employment agreements in plain language. So James is going to walk us through exactly how the tool works and show you it, and what users will see when they actually upload a contract. James?
Hi. Sure. So Here we are on the website, the liftourvoices.org website. And there's a special tab just for this, Love Where You Work AI tool. And you can find it right up here. There are some instructions on how to use it. Essentially, walk through some terms and conditions, choose which state you're working in, upload your material, whether that's a PDF or another document or just text. You can copy and paste text from your document, and then we'll analyze it and you get a report. So agree to some usage terms. And again, you can just paste stuff in here or you can upload a file. So I'll upload a file here. And then it's best to pick your state and agree that this is not legal advice. It will go through and analyze this. And as Julie said, this is highly refined on good and bad contracts, on legal precedent, on current laws, on laws specific to your state, and is very focused on exactly what we're looking for, not just a generic large language model analyzing your data. Now, it'll take some time to read through it, anywhere from 20 seconds to a minute or a bit. And so I've produced, this is the same document already finished. You click View Report, and it shows you your report. Let me zoom in just a little bit. Here we go. And the report is broken up into some sections. Just a quick overview of the contract you uploaded. This one was about a 50-page contract. And it says, here's what you're getting. This is what you receive based on this contract. Here are all the perks, all the benefits, all the good things, the pros. And then it says, here's what you're giving up, all the things that these benefits come with. And in this contract in particular, this is a real contract, you are giving up agreement to maintain strict confidentiality indefinitely. You can't speak out against this company. You have a 12-month non-competition agreement. You have a 24-month non-disparagement agreement. And you release all claims relating to employment and termination subject to arbitration. There's mandatory arbitration for all disputes and a few other things. Bottom line, there are some major issues going on here. And then what it does is it parses out every issue specifically and locates it in the document. So in this case, broad confidentiality obligation. This is a medium or moderate concern. It says this is in section 6 of the document you uploaded. Here's a description of the problem and what this means for you and the recommendation under Hawaiian law, how you can attend to this. There are a few others. Here's a highly concerning, very concerning issue. You have forced arbitration of all claims. This is in section 13. This is very aggressive. Here's a description of what that means and what it means for you and how you can attend to it. And it goes on and it identifies several concerns. And the model isn't looking for a specific number of concerns. It just finds all of them and it iterates a few times through the contract to make sure it hasn't missed anything. And then it tells you, here's how you have power. Here are the things that are problematic, but here's your power. There are laws that support that you can't have NDAs to silence you with regard to sexual harassment or assault. That's illegal. There's the Speak Out Act that gives you power. There's the Ending Forced Arbitration Act that gives you power. And these are specific to the issues found in this specific contract. And then it says, here's what you could do next. It gives you some suggestions. And it also found just some other things. It looks like this agreement appears to automatically terminate consulting payments so they can stop paying you if you decide to move on, which is trouble for your career advancement. Has some basic disclaimers, information about NDAs in general, and you can always download or print your report so you have access to it after you're done on this site. And then always, of course, share with others. You're not sharing your report, you're sharing this tool. All of the information you upload is confidential. We're not keeping this information. We don't keep the contract. This is all anonymous and confidential. And that is the tool at a glance. One other thing I didn't show you is that it is available in Spanish up here. If you click on the Spanish toggle, all of the instructions turn to Spanish and the report that it produces will be in Spanish. That's it.
Amazing, James. I just want to go, thank you for saying that it's anonymous because that's really important, because I know that Obviously, a lot of people may be sensitive to that. And so we wanted to make sure we went through a lot of legal hurdles to make sure that that is exactly how we're handling it. Just to go back to the action items too, because one of the things that we found out in developing this tool was it's one thing to educate people on what's in their contracts, right? Before you sign it, or if you've already signed a contract and you just want to know what your rights are that you've given away. But then we were like, okay, now what do we do once we educate these people, these millions of American workers? What can the American worker do? So the action items that you talked about at the end. So once you get your report,
I can show those again if you'd like.
You can show those again, because these are things, again, we're not giving legal advice, but we definitely think that you should tell other people about the tool, because the more people that know about that's how we start the movement. Also, number 2, don't settle for forced arbitration. And by the way, if we haven't mentioned why it's so unfair, forced arbitration, the intent of forced arbitration was to unclog the court systems because there were just too many cases and small little business disputes. They figured, let's settle those in arbitration. It was never supposed to take care of human rights violations in the workplace, but that's what's happened over time. And so if you sign one of these agreements, it means if you have a problem down the road, you cannot sue. You cannot bring a lawsuit. You cannot go to court. You gave that up on the very first day of work. And why is that not real justice? Well, because you're not going to be in front of a jury of your peers. The arbitrator is going to decide your case, and no offense to James, but they are mostly, and you're not old, James, but older white men who are lawyers and judges. Also, the company has a lot of arbitration cases. So they're going to have the same arbitrator maybe come back who finds in their favor often. But this is your one shot. And the stats prove this out, that the complainant hardly ever wins in arbitration. So we believe it's a rigged system. And so this is why it's so important to not settle for this. We understand, though, if you say, hey, I don't want to sign this, they'll probably go on to the next person. So that's why we're trying to create this movement to have more and more people become educated, more people to start asking for more transparency, which brings us to the third point, which is to form peer-to-peer networks, learn more about the federal and state laws, and of course, follow our work at Lift Our Voices. James, thank you so much. Do you have anything else to add to it? Because I want you to stick around, because I'm sure we're going to have questions from people.
I'll stick around. I have nothing else to add at this point.
Okay.
Thanks. Thanks, James. Well, as Gretchen mentioned, when we soft launched this tool for students at Cardozo Law School a few weeks ago, one of the first questions we got was, okay, now what? If you see something, say something. But on the other hand, if a worker sees something concerning in their contract, how should they approach HR? Other than to let everybody on this in the chat here watching this know HR is not your friend. What questions should they ask, and how do workers advocate for themselves inside a system that often prioritizes institutional protection? And it does. As we keep saying, HR is not your friend. That's why we wanted to bring in Kimberly Williams, who's the founder of Fair Path Project, to help us unpack the real world side of these conversations. She is an expert in all things HR. And so Kimberly, we're so thrilled that you could join us, and thank you.
Thank you for having me. I'm hoping to be your friend today, but you are right. HR is not your friend.
You certainly are.
Some of the more progressive HR people are starting to realize that being transparent in the workplace is really, really important. And you're one of them. So we're very pleased to work with you on other things. And thank you for joining us. So what was your immediate reaction, Kim, when you first saw this tool? And why do you think workers need something like this before they ever walk into an HR office?
Well, you're exactly right. They're giving away the farm before they even sign anything. And most people have no idea that it's in there, because a lot of times it is intentionally buried so that somebody is not going to be able to find that. But I think that there's some like secret HR conversations that may be useful for this, particularly around that question of, okay, well, it's an uncertain job market. I'm really afraid to negotiate. I'm afraid to say no, but there's an awful lot of middle ground in there. And so I think about it a couple different ways. There are still a lot of people who are considered highly valued. If it's a unique job, they really had to work hard in order to get you. You actually have a power position. And I've seen people on the other side of the table use this really effectively. And so a lot of times when people think about negotiation, they're thinking about pay, but benefits is almost more important. And a lot of times it's easier. And even if you don't get a yes, you will change the internal culture. Because I've also seen, you know, with similar types of issues where I'm going to CEOs saying, you've come really close to losing some folks. People are calling us out. Our values are in question. We look really bad. And in much the same way you saw like around pay equity, some folks refuse to do that. But now a few years later, we're seeing if you're not posting those salaries, people don't want to even apply to you. And so even if you don't feel like you're in a high leverage position, simply saying, hey, I just have a few questions around this. You know, why is this in there? This is my understanding that you're kind of disadvantaging me. Is there something I should be concerned with? Even just asking them to explain it is going to put them on their back foot. It's going to make them a little bit uncomfortable. They're going to carry that message forward, and nobody's going to yank a job away from you just for asking a few questions. And so I hope folks feel safe. And then the third thought that I have is for especially, you know, young folks that are out there and they may be interviewing 10, 20 places. They may not even be interested in every one of those jobs. Not to say if it's like a throwaway job, but the more you can introduce that conversation, even if you're taking interviews where you're trying to practice, you're kind of iffy, you just want to feel it out, that is a golden opportunity to say, do you have these silencing mechanisms and why? That's all you have to say. You just ask that question and that will stay in their heads, and it will have a bigger impact than it might feel like.
That's actually a fantastic last point that I think anybody's ever brought up, but really grateful to you for doing that. I want to expand on something, ask you to expand on something that we talked about in the beginning of this, which is that a lot of people do grow up believing HR is there to protect employees. They tell you that that's what their job is. But in reality, we know that HR is at best balancing employee concerns against institutional risk. Most often, it actually is just protecting institutional risk at the expense of employees. So what do workers misunderstand most about that dynamic from your perspective?
I think one good thing to know is that a lot of times things live outside of HR. Like HR, unfortunately, is not a respected or protected field. And I think it might surprise people like how privately HR would love this, because they too face a lot of bullying at work. And if you have a toxic culture, odds are if HR is trying to bring that forward, they're getting punched down at as well. And so if you're in an environment like that, usually you have an executive team that wants things that way. They either want an HR team that's not going to challenge them and they hire them just for that reason, and they're managing them for that, or they're not respected. They're saying, go throw birthday parties, you know, we're going to take out other parts of that equation. So if you're thinking about secondary audiences, like how can I show up through HR? And think one step further. Odds are you're not negotiating with HR, you're negotiating with a CEO or CFO or somebody else through HR. And so by trying to consider that relationship, that can also be really helpful too.
Right. And I just want to answer a question in the chat that's happening. You know, if you do have these conversations, what should you ask for as sort of middle ground? And we always suggest mediation, which we believe is a fairer process than forced arbitration. Of course, our first recommendation would be to not have any, like, take out any kind of mediation, forced arbitration, et cetera. But we believe mediation is better than forced arbitration. So I just want to make sure I mention that. So Kim, once people actually understand what's in their contract, which it's a long time to get there. I know Julie and I didn't know what was in our contracts, and we'd been looking at contracts for years and years. How should they approach their conversations with HR differently then? Because we do want to start this movement of more people asking questions. What should they ask?
Yeah, so at any point in time, HR can introduce new policies, especially if there's a tipping point, you know. So we've seen this over the years, whether it's pay equity and pay transparency. A lot of stuff around pregnancy leave, you know, parental leave. You know, it didn't used to include men several years ago, and now it is everywhere. And a lot of that comes from existing employees applying that pressure. So at any point in time, you could say, hey, you know, you guys have all over the place that you care about employees, that these are your values, these are the things you're doing, and this doesn't really feel consistent. You know, I would be interested in seeing something like this, because they can always change it at any point. They can always soften it at any point. Town hall meetings, you know, really whatever your comfort is. If you know you have leverage, you know you're close to someone who sits at the top, are you using that as an opportunity to say, hey, there's growing awareness around this, and it looks pretty bad that we put people through this. And this can have a real impact in terms of like reputational risk. Consumers may not want to do business with us. hires may not want to work with us, clients may not want to work with us. There could be other things there. And to just keep reminding folks that there could be a penalty for this.
It occurred to me as James was reading that sample contract that somebody actually will have a potential piece of paper they want it to bring to HR from this AI tool, put it on the table and say, line by line, could we go over all of this in ways that I think they probably would not have? So do you think if workers are able to do this, if they start asking tougher questions about NDAs and forced arbitration, especially based on tools like this that actually pressure companies to become more transparent over time, do you think that ultimately does help to move workplace culture more towards the employee side of the ledger?
100%. And I also think it's important that if you have that conversation, you document it. It shouldn't be as scary. Odds are the HR person will be far more nervous with that conversation than the employee will. But if for any reason you are worried, you timestamp it. You go in there and you say, Monday at 1:15, I had a conversation with HR and I specifically brought up these issues because if anything changes afterwards, then you may have a retaliation claim that you want to look at, which is just going to shine a bigger light on the problem and create, more exposure for them.
Thank you so much, Kim, for being so transparent, because I know that you're kind of straddling the fence there. And we want to make the process easier for HR people. And we're hoping your suggestions for trying to change the culture and asking more questions will help us get there. So stick around, Kim, and thank you so much. Miriam, are you available? Because I just wanted to ask one quick question that was in the chat. If she's available,
Yeah.
And that is, so we suggested mediation, if there's a way to get away with not having forced arbitration. Can you answer why you think that might be a better solution?
Well, I mean, really, it's just about the differences between mediation and arbitration. Mediation is not binding. Arbitration is, right? So I think if you are offered mediation, you should go for it because it's at least an opportunity to sit down with a neutral and talk this through and see if you can come to a resolution. The other, your employer has to show up. The facts are going to be on the table. I think that can really help people resolve the dispute. But you can walk out of that room at any point and you're not bound by anything. So it feels like to me, you lose very little by going into mediation. Obviously, anyone listening to this should think carefully about their own situation. We can't advise you what kind of retaliation might follow, what sort of what consequences there might be. But in general, this is just in general, I think mediation can often be a very helpful step.
Yes, great. Thank you so much for jumping in to answer that. So one of the things that has been most meaningful to us throughout this launch is seeing how many different communities immediately understood why this tool matters. NDAs and forced arbitration clauses don't just impact one industry like television or one kind of worker. They affect domestic workers, young workers, immigrant communities, hourly workers, professionals entering their first jobs, people across every sector of the workforce. So we are incredibly grateful to be joined by partners who are already thinking about how this tool can serve their communities that they represent as well. So I want to introduce all of our partners today, and then we're going to one by one just ask them how they're planning to disseminate this to their audiences. So we have the National Domestic Workers Alliance, Alistair Stevenson, Chief Strategy and Impact Officer. We have Merimoto, which is a Latino organization with Yoli Magallanes, Deputy Executive Director. We have Stand with Asian Americans, Zach Siraboom, Chief of Staff and Head of Operations. And we have the Mark Cuban Foundation AI Boot Camps, Lauren Rantz, Director of Partnerships. And we're so grateful to have all of you here today. Alistair, let me start with you, the National Domestic Workers Alliance. Who do you represent?
We represent the 2.2 million domestic workers across the US. NDWA represents nannies, cleaners, home care workers, and we like to say that these workers are the workers that make all other work possible and really are the spine of the economy.
And so when we first contacted you about this tool, and I know you have your own AI tool, which I'm happy to have you share and talk about here. But when we first contacted you, why did you think that this tool would matter to your community?
Yeah, well, domestic workers, as you can imagine, these nannies, cleaners, home care workers, often work inside very private environments, private homes, and often alone and disaggregated from the rest of their workforce. And that usually means that there's no HR department, no shared workplace, and no clear path to support when a problem comes up. And so for a worker facing unpaid wages or unsafe conditions or retaliation or a hard conversation, the first barrier is often basic. It's where do I go and what are my rights? And that support gap matters even more when we look at the data on forced arbitration. We know that the research shows that forced arbitration is more common in low-wage workplaces and affecting women of color, and that most workers subject to forced arbitration make $13 an hour or less, and the median wage for domestic workers is $13.79 per hour. So we knew that there was huge overlap between like what our workforce is experiencing and what this tool aims to correct.
Yeah, thank you for bringing that up, because forced arbitration, as you say, affects low-wage workers, people of color, women. It also affects white men, by the way, though. So it does affect every worker for the most part. But your constituencies are exactly why we wanted to partner, because it affects you more and your communities. One other quick question. So any ideas of how you would try to implement this tool with your constituencies?
Absolutely. So, in addition to some of the problems we've spoken about today, our workers experience all sorts of questions when it comes to their own wages, what their own protections are, what they're entitled to in a workplace. And so already we have been embarking on experiments and our own products to try and get some of this digital power and education in the hands of our workforce who aren't able to access traditional organizing or traditional services that others in similar workplaces might be able to. And so, Gretchen, you mentioned that we are working on our own tool. It's called Ask Aya. It is a complementary AI digital personal assistant. And it is really designed to answer these needs around economic power, about negotiating better pay, benefits, about how to potentially build oneself up in their career. And, like the AI LOV tool, it is private and safe by design, so folks can use it anonymously. And this is really specifically targeted towards domestic workers. And as you can imagine, a lot of the contracts that are faced by domestic workers are, informal or like written in an obscure way. And it's very hard to understand like what the exact contents are. And I think we're really excited about partnering with Lift Our Voices to get a lot of the richness, the complexity, all of this incredible knowledge that you all have been working on into, as a partner with our systems as well, so that we can really like complement each other and provide like one unified experience for domestic workers who also share some of these problems.
Alistair, thank you so much. That was really comprehensive, and we're so glad to be working with you. Julie?
Yeah, and Alistair, I just want to say, as we mentioned briefly, 65% of all workers making $13 or less an hour are bound by arbitration. So when you said your workers on average earn about $13, I mean, that tells us exactly who these arbitration agreements go after, as well as a lot of other people. So thank you so much for that. Yoli, thank you for joining. Tell us a little bit more about Marimoto, who you represent, and why this tool matters to your community.
Absolutely. Thank you so much for having us. I'm so grateful to be a part of this community, and really wanted to start by thanking you for including us and centering our community. It's so important to us. Marimoto is a set of organizations dedicated to building civic, media, and cultural power. As you have seen, our community is very much under attack currently, but our community has been struggling for a really, really long time. And so we want to build a future for our community where we have opportunities and we have equity, and we can fulfill the dreams that we had when our families came here. We organize Latinos into collective civic action. We try to shift culture and drive narratives that illuminate truth. And we try to grow the next generation of leaders. And so everything that we do is rooted in the belief that Latinos have a rightful place in our democracy and in our society. And that's really why this is an important conversation for us. Our community's ability to claim its rightful place in our democracy and society is inextricably linked to their economic well-being. And for the vast majority of our community, that starts at the worksite. When we talk about AI in the future, we also have real budding interest in AI and how it can be used in service of our community. We have to talk about Latino workers. So glad to see our friends at NDWA here as well. Latinos are a core part of this economy. We're disproportionately in jobs where NDAs get buried in onboarding materials. And that's not to mention that a very large percentage of our workforce is not a native English speaker. So there are multiple barriers that are in the way. And this can cost our workers everything. We I cannot overstate just how much people depend on these jobs, and it's such a scary situation to be in. And so you're willing to sign your life away for an opportunity to pay your bills, feed your family. We're construction workers, we're domestic workers, we're warehouse workers, food service workers, and we're really making up a core part of our economy, and we are the essential workers of the United States. So as Miriam noted, the system wasn't even built for working professionals, much less people who may not speak the language. So yeah, let alone the groups that I named. So what really excites me about this is that this puts information directly in people's hands. If a worker can pull out their phone and actually understand what they just signed, what rights they have, what may have been taken away from them, that's not just legal literacy, it's like the beginning of power for us. And that's the moment where someone goes from feeling alone in what happened to them to connecting them to resources and perhaps like the curiosity or the motivation to look into finding others to work with. So we're organizers, and that what you have provided us is an opportunity to give someone a product or a tool to get them not just what they need in that moment, but to also perhaps start a journey for organizing. So we're really proud to be partners in this work, and we're excited about rolling this out to like our community as well. So congratulations, and thank you for having me be here with you today.
Thank you, Yoli, so much. And we're so deeply honored to be partnering with you and hopefully getting this out to your community, which, as you mentioned, very much, first of all, overlaps with Alistair's, and second, just has it is so key to the way that our economy works in this country and is not appreciated to the extent that it should be. So thank you very, very much.
Yeah. Thank you, Yoli. Okay, we're going to go to Stand with Asian Americans and Zach. So Zach, can you explain who Stand with Asian Americans represents?
Yes. First of all, thank you so much to both Gretchen and Julie and Emily and the rest of the Lift Our Voices team for inviting me today to speak. But in terms of who we represent one of the fastest growing demographics in the workforce across the entire country. We've seen large strides and gains in the composition of Asian American workers within the workforce. We also make up a large portion of the highly skilled labor coming in from an immigration perspective when we talk about H-1B visas. And I think that what really resonates with me about this tool is the fact that it is being released out there to provide context for people, right? I think culturally, Asians are typically viewed as the silent worker bees, and we see that throughout the workplace. That's been my experience. I've had many colleagues feel like I can never break through what we call the bamboo ceiling, because it's just, send it over to them. They'll be great. They'll put their head down and they'll just kind of go through it. They'll never raise their hand and raise a voice, right? And I really appreciate that what this tool is doing, right, is giving our people a chance to really understand what they're signing up for and raising their hand, right? It's another identity that is really core to a lot of the people in our community is those are the first generation of professional worker, right? Like I grew up in a restaurant setting. My parents didn't teach me how to read a contract or even question what's in the contract, right? So being able to, and I think Mary mentioned it, right? Like some people, when they get a contract, it's like, okay, how much am I getting paid? Do I get some paid time off? Great. And there's never any questions. And I think that this is so powerful. And again, from an organizational perspective, same with Asian Americans is also here to help with the translation of those details, right? We do have attorneys on staff that can help with that process, but more than anything, I am so grateful to be able to share this with my networks and to give folks another tool in their tool belt, a supplement, if you will, to give them the most amount of knowledge possible to fight for their rights.
Thank you so much, Zach. And I think that this just proves how widespread these silencing mechanisms work across our culture and affect so many of our workers. And it's so many different groups. I should mention that we have so many other partners too that are representing other groups, but these are the 4 that are taking place in our webinar today. So the reach is really vast to how many people that this affects. One other thing I really want to mention before we bring in Lauren too, Julie, is just that there's so much negative press about AI right now. And this is actually a good news thing about AI. Like, this is actually helping American workers. And I can't think of a better, made me think of it because we're going to talk about the AI boot camps in the Mark Cuban Foundation, getting to our young people, which is so essential. Julie?
Yeah, and just to tack on to what you said, we started this a few years ago, trying to develop this, and it's gone through many, many iterations and a very long journey to get here today, which is why this is so exciting. But even in that time that we've been developing it, there have been so many advances in AI that we're keeping up with and continuing to keep up with in this tool, which is why I think Lauren's participation is just so critical. Lauren, you are, of course, here representing the Mark Cuban's AI boot camp. Before you tell us what that is and how you're going to implement this tool with us, I just want to say that what you're doing in reaching young people and getting them into AI and hopefully using AI for good as well as for their own professional development is really critical, and I think part of what we're trying to do here as well. So with that, I'll let you talk a little bit about what you do at Mark Cuban boot camps and also why this tool matters to your community.
Absolutely. So I do want to echo what you just said, Julie, and what Gretchen said, that we live in a world in which people are very rightfully so skeptical of AI and how it is being used. And we can't say that every company and every founder is using it in an ethical way or to empower their employees or their users. And so what really excites us about this tool is that this is one of those shining examples of AI doing good and being used for good and used for the right reasons. And that's to empower people, and that's to empower users in a way that is ethical and a way that is transparent. And that's what we're all about at the Mark Cuban Foundation. So we serve a very diverse set of learners, and our mission is to empower those learners with ethical AI skills and agency so that they can thrive in their communities, wherever those communities may be. And so specifically, we are focused on serving underserved communities. We serve girls, we serve students of color, we serve low to moderate income households, and we serve a lot of first generation college students. And so where we're really excited for this is that, yes, the obvious answer for us is to disseminate this tool in our curriculum and to our students, but it's also to disseminate it to their families. And we have thousands of students and teachers and partners at our fingertips that we can share this out to very proudly. But what is really important is the cyclical conversation that this kind of tool can start. And we know that a lot of our high school students, especially our low to moderate income students, are already in the workforce. They are already contributing to their household income and almost certainly are unaware of what may be in their employment contract. And so it's really important to get this in the hands of our young workers that still have time and still have opportunity to make themselves aware of the language that is affecting them and impacting them, but then to take it to their families as well and ensure that they are just as empowered as they are.
Wonderful. Well, we are so deeply grateful to you and for everything that you do, and specifically that you are working with young people to get them on the right path towards a very rapidly changing technology that could be used for ill, or in this case, can be used for good. So really, really deeply grateful to you for that. And to all of you, thank you for working with us, for doing everything you're doing on your end to really uplift workers, because this is a team project and it's something that I think we're all deeply, deeply engaged in. And very much committed to. So thank you all. We are going to let you go unless there are any questions for this panel from the audience.
I think that we're good. And so
Good.
I'll just echo the thank you very much. And we'll be in touch with all of you as we disseminate this tool out in the coming days. So thank you. I want to bring back Miriam and James and Kim, who kicked off our program, because really what you heard today sits at the intersection of law, technology, workplace culture, and workplace empowerment. And that's why we wanted these three people to join us. So let's talk a little bit, Miriam. You've spent years studying all of these silencing mechanisms. What do you think surprises people the most when they finally learn how much power is hidden inside employment contracts?
I think, and you all, both of you, Julie and Gretchen, know this maybe better than I do because you yourselves were victims of these sorts of agreements. But listening to employees when they find out that they literally have given up their right to band together to litigate what they view as a problem in the workplace, that's really always very striking to people. That they can't talk freely at work about the issues that they're facing, that they've signed away even the right to speak out. This is, I think, really shocking to people. And I have young daughters. I have a 24-year-old who is entering the workplace, and I think young people in particular are not going to take this very well, right? They do not. First of all, they've never believed in privacy. I don't know if my daughter's ever eaten anything that she hasn't documented through many photos. So privacy to them is not a value the way it is for us, right? I think they view it differently. So this idea that you can't know what's happening to the employee next to you, that you can't talk to someone else in your own workplace about something you might be going through, that strikes them as completely bonkers, right? So I think I think we're going to see a sort of sea change. Your tool will be helpful, right, in making that happen. But I do think employees are going to be less inclined to sort of live with these sorts of terms and conditions.
That's a great point. As the mother of a teenager who has zero value for privacy, I totally agree with you.
I don't get it, but yeah.
We live in a very different world.
Yeah.
James, I wanted to ask you, you built this tool for us, amazingly so. And what it basically does is it condenses complicated legal language and makes it understandable for everyday workers. What was the biggest challenge in doing that? Was there anything that you saw while building this tool that really genuinely surprised you about the kind of language companies put into employment agreements? Gretchen and I are so knee deep in this that nothing shocks us anymore, but somebody who wasn't maybe living and breathing this in a personal level the way that we have been, is there anything that really was shocking to you about this?
From that angle, so as soon as you started asking the questions, I was thinking about the technical hurdles I went through. But no, from just coming into this world, because I am not in this world at all. I am a very privileged white male who has never really had to struggle much for anything. And I have an amazing job and life is amazing. I had no idea. That all these things that people were signing away, and I'm sure I've signed some of those things away, even working for an amazing company. With an amazing job, I probably signed away certain rights and I have no idea. I haven't gone back and looked. I should probably stick my contract into this tool and see what I have signed away. Who knows? But yeah, that was very surprising to me. Definitely.
Yeah. We always say that Gretchen and I read things very carefully, and yet we were not particularly well informed about what we were signing back in our Fox News days. So totally understand that now. And
Yep. Shouldn't be embarrassed about that admission at all, James. That's why we're doing the work that we do, and we're glad to have you on board. Okay, so Kim, as we wrap up today, I think it's great to end with you in the sense that coming full circle, once people become educated about these silencing mechanisms, and then it's like, oh my gosh, I have to go over the next big hump of bringing up these things to HR and trying to, am I going to be that person who's the troublemaker and I'm going to say something, which is the way that sometimes it's interpreted. Do you think if more people start asking questions, especially our young people, coming into their first time job? Do you think companies will eventually be forced to rethink how they approach transparency?
Absolutely. And I also think it's important to think about too. A lot of times when we have HR related conversations, we think about a big conversation that gets really scary. But it can actually be just a whole bunch of little drops in the water. So you could be talking to HR about something else and you could just be flagging it. You could just be simply acknowledging it. And even those small steps can accumulate in a way that really sticks in their head, because HR is actually typically quite hungry for feedback from employees. They have an obligation and are usually required to report out on things around this. And so if that's all they're hearing in a non-threatening, casual kind of way, I think that there are more than one ways to deliver a message, so to speak. And so hopefully folks don't feel like it has to be an intimidating effort there.
Well, once again, thank you to Miriam, James, and Kim for sharing your knowledge and your expertise with us today. Really, really appreciate it. And just to wrap things up, folks, for those of you who took some of your day to join us today, we appreciate it. The tool is free. You can access it on liftourvoices.org. It's right there, front and center. Please share it with your friends and family and on social media. And hopefully we can start this sea of change where more people are demanding to own their own stories, their own experiences, and make workplaces more transparent. Julie?
Well, I just want to wrap up by saying that for years now, Gretchen and I have dedicated most of our waking hours through Lift Our Voices to changing laws and challenge systems that silence workers. And we are so proud today to take that work one step further by putting this free, very easy to use tool directly into the hands of workers themselves, so you can take the power back into your own hands and not rely on having to pay lawyers, although this is not a legal tool, but not having to ask HR to decipher something for you. This tool will do that for you. So we are deeply grateful to all of you for joining. Please spread this far and wide. We intend to do that as well. To all of our partners who joined us today, thank you. To Miriam, to James, to Kim, thank you for all of the work that you do, not just with us, but across the board. And thank you to everybody who is going to help us move the needle forward on this very, very important issue.
Have a wonderful day, everyone.
Everybody. Bye. Bye.